So, good afternoon, everyone. So, for today, I have pre-recorded once again our lecture as I am again on travel. Now, as you can see, I'm always on travel, so that's why I'm always particular with attendance because even when I am on travel, I try to attend or pre-record our classes so that you will not miss anything or we will not have any delays in the way we deliver our presentations or our reports or our discussions. So, likewise, I've mentioned last week that we will be discussing Article 6, no? Thoroughly, no? Because this is a very important aspect of criminal law. Kaya ano, why? Because the stages of execution, no, determines the level or the type of penalty that the accused is going to receive once he is convicted of a crime. So this is one of the bases in which the court determines the penalty to be imposed to the accused, especially when he commits felonies or crimes. Okay, so there are three basic stages, no, in the commission of a crime. It's consummated, frustrated, and attempted. No, most of the time you will always hear frustrated murder or attempted murder, frustrated parricide, attempted parricide, no, abortion, frustrated abortion, attempted abortion. But most of the time we do not hear consummated. Kaya ano, why do we not uh necessarily hear about consummated? Because when the crime is actually committed and the crime is produced, it's already consummated. So kung nakapatay ka, then that's already consummated murder or homicide. Then you will be charged for homicide. Di rin nataramayakan consummated homicide because that's already understood that a person was killed, no, because of homicide. One of the requisites or the elements of homicide is, of course, the killing of a person. So, kung may namatay na nga tao, of course, it's either murder or homicide. They will no longer say consummated because it's already understood that when a person dies in the hands of another person, then na-consume na or nahimo na ang crime, then amo na ito ya. Ang gintatawag na ito dida is murder or homicide. So, however, no, these are just examples of those cases that we can actually have consummated, frustrated, and attempted stages. So we have so many provisions under penal laws, no, regarding crimes. But you will understand those concepts better once we go to Book 2 of Criminal Law, which is focused more on the definition of specific crimes. So those crimes will be defined properly or will be more understood according to their definition, to their elements, requisites in Book 2 of Criminal Law. So for now, let's discuss the three basic stages of uh, basic stages, no, of crime. So we have consummated, frustrated, and attempted felonies. So consummated felonies, as well as those which are frustrated and attempted, are punishable. So the general rule is that when a crime is committed, whether fully consummated, whether in the frustrated stage or in the attempted stage, that's already punishable. So if you attempted, no, if you attempted to steal the possession of one item from another person, so gaging kuha mo and usa nga gintry mo pagkuha wala mo yan nakuha but you tried to steal something, then that could already be considered as attempted theft, no? So a felony is consummated when all the elements necessary for its execution are and accomplishment are present. So as I mentioned earlier, there are for every crime defined under the revised penal code, we have the thing called elements. No, in the absence of those elements, there is no crime. So the person could be could actually be set free or acquitted from a charge given to him. No, so um a felony is consummated when all the elements necessary for its execution and accomplishment are present. That's the first requisite for consummated felonies or consummated crimes. So all the elements necessary for the commission of the crime are already what? Already what? Already executed, no? So I'll give you an example of a crime. So, for example, in the crime of adultery. So, in the crime of adultery, no, the elements include number one, the woman is married. Number two, the woman had sexual intercourse with a man, not her husband. And number three, the man she had sexual intercourse is aware that she is married. So these are the elements, no? So if one of the elements here is missing, no, then there is no crime of adultery, no? Because for example, ang main character din man, man. The man is married, no, and the man had sexual intercourse with another, for example, woman, not his wife. Diri siya adultery. Kaya adultery is a gender-based crime. It is only filed against married women. Kaya kung lalaki ito it nag-engage in sexual intercourse with a woman who is not his wife, then diri adultery or ito nagfa-file nga case dapat. Either number one, concubinage, no? Nagkeep hiyahin concubine, no, in the dwelling and had sexual intercourse in a scandalous manner or circumstances with a woman who is not his wife, then the crime would be concubinage. So kung for example, ito sa nga lalaki, a husband has engaged, no? Nasakpan hiya ni asawa nga babayi mo na engaging with sexual intercourse with another woman, and then pagkatuhan kaso ginfile adultery, that will be dismissed. Kaya because the first element is missing. The woman is married, no? Because the the act was what? The act was performed by a man. Okay, kung lalaki hiya, diri hiya liable for adultery. Concubinage probably, but not adultery. So, pag magsayop nga ni filing case, adultery against a man, no, it could be dismissed by the court because again, these elements, they define the crime. They define the acts that constitute a crime. So kung lalaki ito at number one, that's not adultery. No, so kung magsayop pag-filean kaso, that will easily be dismissed by the court because the elements are missing. No, so kung ikaduwa, for example, the woman had sexual intercourse. Pero ngayon, wala man nila mag-sexual intercourse. No, they just nag-date lahira. Nag-date lahira dito ha may seawall or kung diin pa, nag-date lahirahin with a man not her husband. Again, that will not constitute adultery because the sexual intercourse is an element to the crime. If there was no sexual intercourse at the time that they were apprehended, then there is no crime of adultery, no? Because one element again is missing. So again, kung ang babayi nakighilawas had sexual intercourse with her husband himself, there is no crime as well. Kaya the third element is missing. The man she had sexual intercourse is aware that she is married. So And an iyagin ka sexual intercourse is actually her husband. So what crime are you going to file then? Nothing. No, because the elements are missing, or one of the elements is missing, no? So that will not constitute a crime. And remember our principles of criminal law, 'di ba? And also in our human rights laws, because some of you are my students in human rights law, no? The accused shall be presumed innocent unless contrary is proved, no, unless he is established to be guilty beyond reasonable doubt. So, of course, kung missing an element, na-raise ito dayon in reasonable ground, no, or reasonable doubt against the crime. So, yun, na, remember that, no? So, to be consummated, for the crime of adultery to be consummated, the woman should be married in the first place. Kung di riya married and she had sexual intercourse with a man not her husband, there is no crime to speak of, no? Because otherwise, if a case is filed, that again will be dismissed. No, so all these elements to be consummated should be present. The woman is married, the woman had sexual intercourse with a man not her husband, and the man that she had sexual intercourse with is aware that she is married. Kay ano, why is this important? Because the man now, the paramour, no, ang kabit nga lalaki will now also be charged with adultery. No, so those are the things that you have also to consider, because when you file the case of adultery, it is always for two persons. No, the woman who was married and the paramour. No, because if you forgive the woman, kung ginpasaylo mo, so kung ginpasaylo mo an imo asawa, then the man the man who was also her paramour will not be charged anymore, because forgiveness or condonation of the crime of the wife is also a condonation of the crime of the paramour. So, kasi ang main accused talaga din is the wife and not the paramour. So, if you forgive your wife for being adulterous, then it's as good as you have also forgiven the paramour. So, those are also considerations that you have to take when we talk about adultery. So, very complicated, ano? So, ano mat maupay hini? Siyempre, we don't engage in adultery, no? Because ngayon, pagloloko ha mo asawa, you can actually be charged for that. But adultery is a gender-based crime, so it is only for against the woman. Again, for man naman, lalaki naman nga naglilinorong, the possible cases that you can file for a husband or a philanderous husband. Ano't philanderous? Ito nga ni nga, biskon hinula, or may dahiya kabit mismo, and they are engaging in such scandalous activities, then um you can file concubinage. But if you are the wife and you are suffering from psychological distress because of the womanizing of your husband, so pwede ka gihapon mag-file in violence against women and children, no? So may mga instances wherein we can actually redress our grievances against a philandering, no, womanizing or unfaithful spouses naton, no? Okay, so that's clear, ha? So to be consummated, the elements defined or provided in the provisions of the our criminal code, as well as other special penal laws, should be present. No, otherwise, if one is missing or all are missing, then there is no crime to speak of. And then if the case is filed, it will just be what? It will just be dismissed. Okay. Now let's go to um frustrated. The crime is frustrated when the offender performs all the acts of execution which would produce the felony as a consequence, but which nevertheless do not produce it by reason of causes independent of the will of the perpetrator. So, for example, he tried to kill Marshall, no, sigunte ni Polano nga ni Marshall, magkaaway hira. So, Polano tried to kill Marshall by stabbing him 7 times. So, with the number of stab wounds, no, there is actually prima facie evidence that Polano really intended to kill Marshall. But then, uh, um, may ada bystander sigunta nala he Badong, no, he Badong, he was a bystander and he saw what happened between Polano and Marshall. So while Polano and Marshall was having a fight, no, and Polano was trying to kill Marshall, he called 911, he called for emergency, and then suddenly the police officers came, no, and then the altercation was stopped, and then Polano was apprehended. So because there was an ambulance that came immediately, so he was rushed to the hospital and was able to survive the attack. But take note, when the doctors the stab wounds, um, kasi under several Supreme Court decisions, no, the stab wounds, no, are the number of stab wounds and where the stab wounds were actually inflicted can help determine whether the intention of the perpetrator is just to inflict physical injuries or to actually kill the person. So Marshall, he suffered 7 stab wounds from the incident. So definitely from there, we can infer, no, we can presume, no, there's a presumption that Polano really intended to kill Marshall. But then Marshall survived. Why? Because there Badong called for the ambulance and the ambulance came early. So yun, nagkamiadahin medical attendance. So why? Because the crime of homicide was not produced by reason of causes independent of the will of the perpetrator. So because of reasons to which Polano could not actually control, no, because of the immediate medical attendance procured by Badong, no. So it was not controlled. It was a situation not controlled by Polano. So now he could be held liable for what? Frustrated homicide because all the elements are present, no? He tried to kill Marshall by inflicting severe stab wounds to Marshall. But then, even so, because of reasons independent of his will, because of reasons that he could not personally control, no, because there were some extenuating circumstances in his surroundings, the crime was not committed or homicide or uh Marshall did not die. So you cannot file. If there is no death, you cannot actually file for homicide. Because homicide, one of the elements there is that a person should have died. But then Marshall did not die. So what will happen now? Then the crime committed is actually frustrated homicide. So Polano was able to execute all the elements, but still the crime was not committed by reason or causes independent of the will of the perpetrator. So I hope that's very clear, ha? So if you have any questions, just um you can comment probably in the video that I will be posting through this video. You can just comment, no, in the comment box. So I will enable the comment box for now so that I can also check whether you have any concerns regarding our discussion for this afternoon. Next, Let's go to attempted. There is an attempt when the offender commences the commission of a felony directly by overt acts. No, overt acts gani, we are talking about external acts. Those actions na talaga that has an effect in the outside world. So, there is an attempt when the offender commences, nag-start na hiya pag-commithan felony directly by overt acts. But he does not perform all the acts of execution which should produce the felony by reason of some cause or accident other than his own spontaneous desistance. No? So, for example, Hipulano, no? May danahiya knife, may danahiya to, sundang, whatsoever. So he was about to stab. At mas-strike na talaga hiya. So may danahiya action, no, mas-strike na hiya kan Marshall. But then he badong, because he was really trying to save Marshall, ginpugnan niya Hipulano. No? So ngayon, Hipulano, waray niya, kaigo he Marshall, no, but he already performed the preparatory acts, no. So gingkuha na niya sundang, may daradara niya sundang, nag-attempt na hiya kung daradara la, okay lang, there's no crime of attempted homicide. But then if he started to strike, no, nagtikang nahiya mataw-taw na unta hiya kan Marshall, but then he was apprehended by Badong, no? Umagi Badong napugnan niya Hipulano. So there was no strike. Waray niya kaigo hi Marshall, but he was about to. So he already commenced the act or the attempt. He has already attempted. So what's now the difference between uh frustrated and attempted? So how frustrated, may na-strike na, may naigo, no? So na nag-suffer na hin some sort of injury, he victim. While in the attempted stage, waray pahiya kaigo. Matikang palaunta, but then by reason of cause or accident other than his own spontaneous desistance. Kay ano, kay gimpugnan man hiya ni Badong. But kung he Pulano mismo, masiring na unta hiya, but then nakapaghunahuna hiya, agi, hindi na ako hini, kay may pamilya ako, mapipriso ako. So he decided to put down the knife himself. So that is his own spontaneous desistance. So what are ito crime? Probably grave threats, but not homicide, not for homicide, no? Not for attempted homicide. No, because at the attempted homicide, there must be an overt act already. No, may na, ready to strike ka na, but then you were not able to strike the victim, or the accused was not able to strike the victim because of some causes or accident, not of his own choice. So, gimpugnan hiyan ibang nga tao or mga sugad ito nga mga instances, not because hiya mismo andi rin na gusto himuon ito nga crime. No, because if there was spontaneous desistance, siya mismo ang nagpugong haya kalugaringon, it's not because of some causes, other causes or accident, then there will be no crime of homicide. Now, grave threats probably, or threats probably, no, but no longer homicide. Okay? Okay. So those are the main difference between consummated, frustrated, and attempted. So again, we go back to the basic concepts. Consummated felonies, all the elements are present and the crime is produced. No? Frustrated felonies, all the elements are present, but then the crime is not produced because of causes independent of the will of the perpetrator. That's the main difference from consummated. Consummated, there's the body of the crime is produced. So in frustrated, the elements were all executed, the elements are present, but then there was no crime. I mean, the crime was not produced. So if the intent was to kill, the victim was not killed. Probably just injured but not killed. No, so yun, that's frustrated already because of causes, and it became frustrated because there are some causes independent of the will of the perpetrator. And attempted stage naman, no, the accused has already began the commission of the felony by overt acts, but he was not able to complete, no, or to execute all the elements, or to complete the act to constitute the crime because of causes or accidents other than his own spontaneous desistance. So, at spontaneous desistance, he himself has decided not to do it anymore. So, yun, no? Hinhi, because of causes other than, karog signgon, except nga hiya mismo, no, ang nag-decide na not to do the crime anymore. Okay. So adultery, those are the elements. Again, if all the elements are present and the crime is committed, then there's already consummated adultery. So the case will be adultery. No, so here, for example, um, yun, um, l- in frustrated adultery naman, all the elements are there, but the crime is not committed. So, for example, they were about to have sexual intercourse, but then because of some causes independent of the will of the perpetrators, they were not able to finish the fully consummate the sexual intercourse. Then that could be considered as frustrated. And attempted stage naman is when they were about to start, no, the sexual intercourse, but they had to stop because of what? Causes in the other than their own spontaneous desistance. So nakabatihira, no, they were about to have sexual intercourse. They were already there. They were already naked, but then some persons came, and then yun, they had to stop what they were doing. Oh, so that could be attempted. Now let's go to the development of crime. So there are three main stages, 'di ba? Consummated, frustrated, and attempted. But then let's try to understand how the stages of the acts are defined under the law. So there are two types of acts, no, internal acts and external acts. In our previous discussions, I've already told you, internal acts such as mere ideas in the mind of a person are not punishable, even if had they been carried out, they would constitute a crime. So again, if you're just thinking about those plans to kill someone and you are not actually executing them, that does not constitute a crime. No matter how bad or vile or evil your thoughts are, they are not punishable under our laws. However, now we go to external acts. External acts now, those are actual actions and have certain repercussions in the outside world. So in external acts, there are two types of acts: preparatory acts and acts of execution. So preparatory acts, from the name itself, nagpre-prepare ka pala. No, but ordinarily, they are not punishable. For example, buying poison or carrying a weapon with which to kill the intended victim. So you wanted to kill someone, so you already bought poison, no, from the pharmacy. So you wanted to administer what are poisonous substances, no? Basta there are so many poisonous substances actually that we can administer to some person. So, inihiya, he was planning, Polano was planning to kill Marshall. So, amot aton mga starring yan na ano, Polano nga ni Marshall. So, Polano was planning to kill Marshall, and he planned, no, his plan was to ask Marshall for a drinking spree. Makikig-inom hiya kan Marshall. And while Marshall is drunk, dito niya that's the time that he will administer the poison. Ibubutang niya dito hanggang inom ni Marshall. So, Hippolyta, because of his plans, he bought the poison. So, is that act now punishable? No. No. Because buying poison does not constitute a crime. No, because there are authorized reasons to which we can buy poison. We can buy them as long as we are not violating any other laws. No, because buying poison itself is not punishable under our laws. So number two, carrying inflammable materials to the place where a house is to be burned. No, for example, si Hippolyto, again, he planned to kill Marshall, and he wanted to commit arson. So he wanted to burn Marshall inside his house. So because of that plan, he bought gasoline from the gasoline station. Is the act of buying gasoline from the gasoline station punishable? No. So these are just preparatory acts. It's those acts are preparatory, of course, in preparation to commit a crime. But nonetheless, preparatory acts are generally not punishable. Okay? Except for other instances where there is a presumption under the law. So later we will discuss what are presumptions, because there are presumptions under the law. For example, no, one presumption is that, for example, um an adult male, medyo may edad na nga lalaki, is found to be with a 10-year-old girl inside a hotel room, no? So under the law, under our laws, there is a presumption of child abuse or rape if an adult male who is not a relative of a child, and they are both found to be inside a hotel room, no, there is a presumption. What is presumption? Is that the law presumes, no, if those facts are present, the law presumes that that adult person together found to be together with a child who is not a relative, or who is not related to the child, he could be held guilty or liable for attempted rape or child abuse. Okay? So those are, or prostitution. No, so those are things that we have to consider, and we will know certain presumptions under the law. So these presumptions really are present. So if these instances no are present in cases, even if there is no direct evidence, the person could still be held liable for some criminal offenses, no? So now let's go to letter to B, acts of execution. So now this is now the not just preparatory acts, but the acts itself of what? Of acting out the crime that we wanted to commit. So those are now acts of execution, the consummated, frustrated, and the attempted stage. Meaning we have already executed all the necessary elements to commit the crime. Okay, so why is this important? So we go back to the provisions on penalty. Why is it that it's important to know whether the offense is in attempted stage, frustrated stage, and in the consummated stage? So we have a table here. So this is just an advanced discussion of what we are going to also discuss in the future, because this is in the later part of the revised penal code, I think around Article 48. That's where we begin the discussion on penalties. But this is just a short overview of generally the the penalties under criminal law. So arresto menor constitute 1 month, 1 day to 1 month of imprisonment. No, arresto mayor, from starting from arresto mayor, you always have to remember there is always a plus 1 day. No, because otherwise, if the penalty is 1 month, then it is under arresto menor. But if it's 1 month and 1 day to 6 months, that's already arresto mayor. So you would notice from arresto mayor going to the reclusion perpetua, there's always a 1 day plus 1 day for the minimum, no, and no longer in the maximum. Okay, so arresto mayor is one month plus 1 day to 6 months. Prison correctional is 6 months plus 1 day to 6 years of imprisonment. Prison mayor is 6 years from plus 1 day to 12 years of imprisonment. Reclusion temporal is 12 years plus 1 day to 20 years of imprisonment. Reclusion perpetua, which is the highest penalty, because before we had the death penalty, but that is execution of death penalty is currently suspended. We still have the death penalty law. It's just that execution. There was a law also suspending the execution of death penalty. Reclusion perpetua is 20 years plus 1 day to 40 years. Okay, so the maximum number of years now of imprisonment would be at 40 years. So why is this important? So, in determining the penalty, these are actually considered as degrees dito. Ini, from arresto minor to reclusion perpetua, these are what? Penalties, no? These are degrees. No, they are considered as degrees, no? Arresto menor, arresto mayor, reclusion correctional, reclusion temporal, reclusion perpetua. So you would notice here now, disregard lanay and principal, accomplice, and the accessory because we will also be discussing them very soon. But let's first try to see consummated, frustrated, and attempted. So, for consummated felonies, because the crime is definitely committed, then the full penalty will be prescribed. For example, if the case is murder or rape or statutory rape or qualified rape, then that would be reclusion perpetua, no? Ordinarily, generally. So, again, no, qualified rape, statutory rape, murder, reclusion perpetua, ito general, general penalty. But then, if the degree of accomplishment is only frustrated, no, it's only in the frustrated stage. It's going to be 1 degree lower. So for example, if the penalty of murder is 20 years plus 1 day to 40 years, um and then the stage of execution is only in the frustrated stage, no? Paras kanina kan Polano ngan Marshall. Marshall already executed all the elements necessary to commit the crime, but then sorry, Pulano already executed, but then Marshall did not die, no? So it's in the frustrated stage. It's going to be the penalty will be 1 degree lower. So instead of reclusion perpetua, which will be 20 years plus 1 day to 40 years, the penalty will now be 12 years from 1 day to 20 years. So imagine, no, there's a big difference from the consummated, frustrated, and attempted stage. Why is the consummated why does the consummated stage have the full penalty? Because it's the full crime. So it will receive the full penalty. If it's in the frustrated stage, then it will be 1 degree lower. So instead of having to spend time for up to 20 years in prison, now the perpetrator will just have to spend 20 years. If it's in the frustrated years, maximum of 20 years of imprisonment. No. So now, in attempted, again, what is the attempted stage? The perpetrator already commenced the execution of crime but was not able to complete all the acts necessary for the commission. Again, by reasons other than his own spontaneous desistance. So, 2 degrees lower than consummated. No, so now, if the crime is in the attempted stage, the penalty now will be 6 years plus 1 day to 12 years maximum. It will now be lowered down to prison mayor. So the the rule. If it's in consummated stage, then the perpetrator generally, unless otherwise there are mitigating circumstances, the perpetrator will have to be penalized for the full extent of the penalties prescribed by the revised penal code. If it's frustrated, it will be 1 degree lower. So if it's murder, frustrated murder will have reclusion temporal. But if it's attempted murder, it's 2 stages lower than the consummated stage, then the penalty will be prison mayor. But that is the general rule, ha. We still have to discuss mitigating circumstances. Okay, so mitigating circumstances also can likewise lower down the penalty, the imposable penalties of the crimes itself. Okay, so I hope you understand the discussion. If you do have any questions regarding this one, just kindly take note of them and we will discuss them on Wednesday. Now, we will be meeting on Wednesday definitely. And if you have any questions, we will have a short review in this one and we will proceed with the next topics that we are supposed to discuss. Okay? So for the meantime, that's going to be our discussion for today: consummated, frustrated, and attempted felonies. So by next meeting, we will be discussing light felonies, grave felonies, some of the penalties, and of course, we will now go to the exciting part, which will be on the mitigating, justifying, um, aggravating, and alternative circumstances. So those are very exciting those are very exciting concepts of criminal law, and which I want you to be able to fully understand. So if you do have any questions, especially on the concepts that I am teaching, please tell me immediately. Just notify me in the next meeting. Just take note of the questions that you have for today's discussion. But for the meantime, I will let you go so that you can also take some rest and enjoy the rest of your evening. So I'll just see you again on Wednesday. So please, again, prepare for a recitation. And if you do have any questions that you would want to raise, just raise them during our discussion before we begin our discussion on the next articles under the revised penal code. So that's it for today, class. I'll see you again on Wednesday. Okay, so I will be present on Wednesday. And for the meantime, please take care and review the discussions that we had today. So see you again on Wednesday and good evening.